Hello, today I'm going to talk to you about disability accommodations in the workplace, specifically in New York City. So, in the United States, under federal law, people with disability are entitled to reasonable accommodations from their employer. But there are also many state and local laws that similarly require disability accommodations. Today I'm going to focus on the New York City law. In 2018, a new New York City law was passed that requires employers and employees to engage in a cooperative dialogue to determine whether or not an employee needs a disability accommodation and how they can be accommodated. So basically, employees and employers are required to communicate and to talk to each other, which seems very reasonable. Basically, disabilities come in so many different, there's so many different types of disabilities, and there's so many different accommodations depending on the workplace and the person. So that's why communication is so important, because every accommodation is very tailored to the specific person, their disability, their job, and what the employer can realistically accommodate. So anyway, in April of 2019, the New York City Commission on Human Rights released some guidance on how to interpret this new rule, this new requirement of having cooperative dialogues. So that's what I'm going to talk to you about today. So, first of all, initiating the cooperative dialogue. How does it start? Whose duty is it to start the cooperative dialogue? So the cooperative dialogue can either start when an employee informs her employer of her disability and explicitly requests an accommodation, or it can start when an employer has a reasonable basis to believe that the employee has a disability that is affecting his work performance. So basically, this means that an employer must begin the cooperative dialogue if they think that an employee might have a disability and might need an accommodation. It's not always the employee's job to ask for the accommodation. Now, the employer still has to be a little careful. They can't just outright ask the person if they have a disability. So they'd have to approach it something like this, where, a manager goes to an employee and opens up the conversation by asking the employee, is there anything going on in your life that, the employer can help with? They can mention that reasonable accommodations are available, and they can direct the employee to a workplace policy on reasonable accommodations. If the employee, decides that they don't want to engage and they don't follow up on that conversation, then the employer has fulfilled its duty to attempt to start the cooperative dialogue. If the employee, decides at a later time to initiate the cooperative dialogue, that's fine. Just because they didn't want to do it on the employer's timeline does not mean that they can't bring it up later. It just means that the employer fulfilled its duty, and now the ball is in the court of the employee. Okay, so that's starting the cooperative dialogue. Now, what exactly is the cooperative dialogue itself? So the purpose of the cooperative dialogue is for a person with a disability to explain their individualized needs to their employer, and for the employer to understand those needs and explore ways in which they can meet them. So a well-functioning cooperative dialogue could be thought of as a team brainstorming, kind of. Obviously, it's a bit more formal than that, but it shouldn't be an adversarial process. It should be one where both sides are trying to find a solution together. both the employer and employee must be communicating in good faith. This means an employee cannot simply reject a reasonable accommodation because it's not the preferred accommodation, even if the accommodation meets their needs. It also means that an employer must continue to search for an accommodation if the employee rejects their first offer as not meeting their needs. So basically, it's not just one and done. Both sides have to be willing to, negotiate, be willing to accept something that's workable, but maybe not their first choice. Overall, the New York City Commission looks at the following 3 factors to decide if the employer and employee engaged in the cooperative dialogue in good faith. These factors are: 1, whether the employer has a policy informing employees on how to request an accommodation based on disability. 2, whether the employer responded in a timely manner in light of the urgency and reasonableness of the request. And 3, whether the employer sought to obstruct or delay the cooperative dialogue or in any way intimidate or deter the individual from requesting the accommodation. So the first step is a policy. So that's something that, could be in place before there's a problem and before the cooperative dialogue even starts. That signals that the employer is open to engaging in the cooperative dialogue. The second is just timeliness. If the employer sits on a request and never responds, then that is in effect stopping the conversation. So both sides have to get back to each other within a certain amount of time to show that they're engaging in good faith. And the third one, I think, is just common sense. If the employer is trying to intimidate the employee and stop them from requesting an accommodation, then clearly that's not good faith. So finally, the conclusion of the cooperative dialogue. How does it end? So there are 4 different ways that it could end. The first one is an employer offers the employee a reasonable accommodation, which they accept. Then the employer grants the employee that reasonable accommodation. Okay, that sounds pretty good. Number 2, the employer determines that there is no accommodation available that will not cause undue hardship to the business. So there could be situations where that's the case, and that's unfortunate, but that could be another way that it ends. 3, the employer offers the employee a reasonable accommodation which meets their needs, but the employee does not accept it, and no reasonable alternative was identified during the cooperative dialogue. So that's basically on the employee if the accommodation does meet their needs, but they don't want to accept it. And finally, 4, no reasonable accommodation exists that will allow the employee to perform the essential requirements of their job. So those are the 4 ways that it could go. Regardless of which one of those it is, when the employer determines to either offer an accommodation or that no accommodation can be made, they must inform the employee in writing of their determination. So this is a new part of the New York City law, that there must be something in writing at the end of the cooperative dialogue. And, if there is no cooperative dialogue at all, or there's nothing in writing at the end, then the commission could fine the employer for not doing that. So yeah, that is basically a summary of how employees and employers should talk to each other and work together to find accommodations for people with disabilities in the workplace. If you want more information about disability discrimination, what is a disability, then you can find that on my previous blog post about disability discrimination. And I'll also be putting up a new video with some more examples of situations given in the New York City Commission's guidance that describe, different ways that the cooperative dialogue could go. Thank you so much for watching. See you next time.